Hello everyone, welcome back to the LegalEase channel. Today we are going to discuss about a new topic, that is Res Sub-judice. We have already discussed about Res Judicata. We have seen the meaning of Res Judicata, the meaning of all the essentials of Res Judicata, and we have also seen the meaning of constructive Res Judicata. Today we'll start with Res Sub-judice. So Res Sub-judice, first of all, it is given under Section 10 of CPC, and the language is this of the Bare Act. So if we talk about the meaning and the intention behind Section 10, the objective is almost similar to Res Judicata, but the difference or the main difference between Section 10 and Section 11 is that Section 10 or Res Sub-judice is applicable when a formal suit is pending, while in Res Judicata we have seen that it is applicable when the suit has decided, heard and finally decided. So if it is decided, then Res Judicata will be applicable. If it is pending, then Res Sub-judice will be applicable. That is one of the main difference. Now let's move on to the whole body of Res Sub-judice. This is also called as stay on suit. The language used in the Bare Act in the head note is talking about stay on suit. So we'll just see the language. It says no court shall proceed. So again, like any other, like the res judicata, it also put a restriction on all the courts, and it is putting a restriction on the proceeding. So in res judicata, the bar was on the trial. It said no court shall try. यहाँ पे है no court shall proceed. So proceed means that no court shall move ahead. That means if a suit is instituted and a formal suit is already pending with the requirements that are mentioned under this particular section, then the subsequent suit will be put on stay. So a stay will be put on that subsequent suit. Until the time this formal suit is decided, the second suit will not continue. So no court shall proceed with the trial of any suit. Again here, when we talk about res judicata, it says any suit or any issue. So suit or issue, both these things are used in res judicata, but in sub-judice only the suit is involved. So if a particular matter between A and B includes 1, 2, and 3 issues, and the same matter is filed in a separate court with the 3, 4, and 5 issue, then in this particular case, the subsequent suit will not be barred or will not be facing any stay. The reason being that this particular suit, the subsequent suit, is not exactly similar to the former suit. If both the suits are same, all the matters are same, then only stay will be there. If it is not same, then stay will not be there. So this is also one of the difference, because res judicata is applicable even if this one of the issue is same, but sub-judice is applicable only when all of the issues are same, in which the matter in issue is also directly and substantially in issue in a previously instituted suit. So we will see that the matter should be directly and substantially in issue. As we have seen in res judicata, the meaning of directly and substantially in issue is applicable in the same way. Between the same parties, again, the meaning is same, that the parties should be same, A versus B and B versus A. Parties whom under they or any of them claim, again, like legal heir of A or legal heir of B, or any person who is deriving the title, who is deriving their interest in the property from someone else who has already fought the case, or under the same title, for which also I have already explained the meaning with the examples when we can say the title is same and when we can say the title is different. So for the details of these terms, you can also refer to my video on res judicata, which explain all these terms, and the same explanation, the same meaning is interpreted in this particular provision as well. Where such suit is pending in the same or any other court in India. Here the restriction has been put about a court either way which is in India, which has the jurisdiction to grant relief. Again, jurisdiction to grant relief means the court should be competent. So any case which is pending in an Indian court which is competent to decide, if some similar case with the same matter is filed in some another court within India, again having the competency, then Section 10 will be applicable. Or if in any court beyond the limits of India, but established or continued by the central government of India. So if there is any country, for example, Nepal, any court in Nepal is established by Indian government, then in that particular court also, the rule of Section 10 will be applicable. That means if any suit is pending in that court of Nepal, which is established by the Indian government, then in those cases, that particular suit will be barred to be tried or will be put on a stay if it is filed again in Indian court. Yes, नेपाल कोर्ट का भी बार उस पे इंडियन कोर्ट पे लगेगा अगर वो नेपाल कोर्ट जो है वो इंडियन गवर्नमेंट ने स्टैब्लिश की and having like jurisdiction or before the Supreme Court. If a suit is filed again before the Supreme Court and it is pending in the Supreme Court, it cannot be tried in any other court. Or if a suit is pending in any other court, then it cannot be filed in a Supreme Court if all the other conditions that are mentioned in the body are fulfilled. So basically, it has to bring more clarity. It has specified that any Indian court will be so Section 10 will be applicable on any Indian court, any foreign court or any court which is on a foreign jurisdiction but established by the central government of India. And the third is that it can be a Supreme Court also. यहाँ पे इन्होंने Supreme Court इसलिए add किया so that more clarity can be given. But explanation is also provided here, which says the pendency of a suit in a foreign court does not preclude the court in India from trying a suit founded on the same cause of action. For details, let's discuss this. Let's suppose there is a court in Canada wherein court in Canada is there, Canadian court, wherein A and B are the husband and wife who have filed their case for divorce. Okay. While this particular suit was pending in Canada, one of the party came to India and filed another case of divorce in India. In this particular case, the parties cannot say that this particular suit, which is a subsequent suit, will be barred by res sub-judice. The reason being Section 10's explanation specifically says that any case pending in a foreign court will not put a bar on the same case in an Indian court. So both these cases can run together. One more important thing, like we have seen in res judicata, the former suit and subsequent suit is decided on the basis of the date of decision and not of the institution. But in res sub-judice, the date or basically to determine whether a suit is a former suit or a subsequent suit is decided on the basis of the date of institution of the suit because the decision has not come yet. So we will not be able to determine on the basis of the decision. So a suit which is filed or instituted first is the former suit. The suit instituted later is a subsequent suit. The bar which is put on subsequent suit that they have to put a stay on a decision that has come or on a case that has come before them for trial can be exercised by that court only. No other court can put a stay under Section 10 of CPC. So again, let's suppose there is a court in Mumbai and wherein the suit was filed. And again, there is a court in Pune wherein the subsequent suit is filed. The same cause of action, same parties and all these things there. And then the Mumbai court cannot put a restriction or cannot put a stay on Pune court saying that the same case has come before you, that's why you should put a stay. Only the Pune court has the power to put such stay. Mumbai court will not interfere and cannot interfere. So that is also one of the important point. If at all a higher court than that of the court mentioned in which the suit is filed, let's suppose High Court want to put a stay, High Court can do that, but this power is not under Section 10. It will be under 151 in the interest of justice and to prevent abuse of the process of court. So higher court can do it under their inherent powers, but the lower courts, the court where the suit is filed, can do only in respect to a case which is pending before them and not for any case which is pending in some other court. No court can direct the other court to put a stay on a suit which is already pending in their court. One more thing, there are certain exceptions to Section 10, like whenever there is a case of injunction or interlocutory orders or stay, like Order 39 is there under CPC. In those cases, the Section 10 will not apply. The reason being because these particular sections or these orders that I'm talking about are related to a relief which is temporary in nature and not permanent and given to a party for some time. So if a particular case is pending wherein an application for injunction is also pending and same application is filed in another court, the court which is going to try first will be given preference and both the court can shall try this particular case or can try this particular case. The reason is that the party should not feel that the justice is delayed because of a stay put on one case and the second, the former court is already continuing it. Since it is a temporary remedy, it should be made available without any restriction, and that's why the provision is like that. So I hope all these points related to res sub judice is clear to you. There is nothing much to be discussed in this. There's nothing much to be uh, explained in this particular provision. It is almost similar to that of section 11. The only difference is it is filed during the pendency of the suit, or it is filed only when this one suit is pending. The definition to determine what is a former suit and a subsequent suit is different. The third thing is that in this particular case, in section 10, stay is put and not a bar is put on the trial or the institution of the suit. Fourth thing is, it is section 10 is applicable in the whole suit when it is common, while section 11 can be applied on an common issue as well. So these are some of the important and the common differences between the two. The question is, one of the very important question is that since explanation of res sub-judice provide that a foreign court, if it has given a decision or if any particular case is pending in a foreign court, then the same case can be tried in an Indian court as well, and this restriction will not be applicable. So both these cases can go simultaneously. You have to tell me in the comment section whether this is applicable or whether you can actually apply the same logic in case of res judicata. So, if a foreign court has passed a decision or a decree is given or a judgment is given by a foreign court, will that judgment bar the Indian court in taking up the same matter, or like res sub judice, the Indian court can also decide again on the same matter? So, I hope you will be putting your answer in the comment section. And if it is not clear to you, I will answer it in the next or upcoming videos that I will be delivering to you in the upcoming classes. So this is it for today. Thank you and have a nice. Bye bye.